Every Friday, we get a little lesson in the law, 5 minutes of education on legal nuances that can really help if you're ever hurt in an accident. So back with today's lesson, we have Colorado's best attorney, Phil Harding from Harding and Associates here. You know, it's always good to get the lessons from you. I mean, people really do remember them when they come into a critical time in their life. They're like, I remember what Phil told me.
Good.
You've taught us all a lot. So what are you teaching us today?
Hey, you know what? I recently had an attorney call me and wanted me to try their case. And during my analysis, I looked not only at the good and bad of each case, but also scratched my head and said, why isn't this case settled? So I want to explain to our viewers how to analyze a case for trial and give our viewers that insight to understand why some cases go to trial and why some settle, so that our viewers can have a better understanding on better positioning themselves.
Yeah. So when it comes to, settling and actually going to trial, I mean, what is the breakdown? I mean, what percentage is settled and what actually goes to trial?
Yeah, great question. And now here I'm only talking about civil cases, not criminal, but generally more than 20% of, not 20, 90% of all cases settled before trial.
90, okay.
90. And I want to look at today the who, what, when, where, and why of settlement. And let's start off with the when. We have a graphic for it, and it's so important. And first of all, you see this thing, GIA? It's called the Governmental Immunity Act. Now, generically, for a breach of contract, it's 3 years, auto accidents, 3 years, and slip and fall is 2 years. But this GIA means the Governmental Immunity Act. So if the government caused your injury, a county assessor, you got in a car wreck with them, you have to give them notice within this 180-day window.
That's a pretty quick turnaround.
After the accident occurred, and then you get the regular statute of limitations.
Okay.
Now, also, you only want to settle after you know all of your damages. For example, not halfway through your treating and settle your case. Know that and know what all of your damages are. Next, let's talk about what you need to settle this case. And here it is. You need to have your theory of your case, which essentially why you're right, why the other person is wrong. All your damages, which is your economic losses, your medical bills, lost time from work and the like. Also your medical bills only showing the amount billed, not versus paid. We talked about that all the time, so if people are confused, give me a call or go to KWGN and see some of these old ones.
Yeah, you've educated us on that a lot.
And then records with proper redactions. Let me tell you what that means. When you're sending in medical bills, don't send anything about a hangnail that you had in 3rd grade or something non-related. You can redact that out. And then finally, know your risk. And let's talk about this last area, which is know your risk, which is why I was tried into to try this case. I don't think that the attorney actually knew his risk or was respected by the other side. So that's why this case was going to trial. To fully appreciate your risk, you need to know the law, and you need to know who's on the other side, who's the attorney on the other side. It sounds easy and basic, but too many people miss the point. Your best way to settle a case is either with a well-educated attorney on the other side, and on your side to guide you through your process. Look, I love it when I'm dealing with a sophisticated attorney. If so, the other side is going to know the risk. They're going to know that a trial is really only a last resort when one party isn't being reasonable. I love dealing with large companies and insurance companies because they go through this risk analysis all the time. In doing so, sometimes they know if they're against an attorney that doesn't have any experience, doesn't try cases. So what they're going to do, the other side is going to drag this out, maybe to the E before trial, or maybe even try this case and outshine them in court. Yeah.
Well, I can see that, you know how to size up other attorneys, but how would I know, or how would anyone else know how to choose the right attorney?
Yeah, and we've talked about this before, and there's some other segments on. But look, go over and look. Make sure that you have an attorney that practices in this area. Also, most importantly, find an attorney that you can communicate directly with. Now, don't go through a case administrator, don't go through a paralegal. If you never hear from your attorney, then that means they have too many cases. Next, I want to look at why to settle. First, you need to realize that all settlement negotiations are totally inadmissible. Colorado Rules of Evidence 408 specifically says that evidence of the following is not admissible: valuable consideration, in other words, offering money. And then the next one is conduct or statements made during these valuable negotiations. So if any statements were made in the settlement process, again, those are called 408 discussions, totally inadmissible.
So why aren't those allowed in court? Because sometimes when you see the shows, it's like, oh, that's not going to be admissible. And you get so frustrated. Why? Why isn't it admissible?
Yeah, well, here, and look, I love 408 because courts know that when people try really hard to settle cases and keep it out of court, that's in everyone's best interest. The court realizes that a settlement that both parties agree to themselves on, even if it's like, man, I shouldn't have accepted so little, that is so much better than a judgment being forced upon them either by a judge or a jury. Now this brings us to the final issue of settlements, which is the best settlement is really where both parties walk out going, man, I got a raw end of the deal. Where both parties really walk away from that saying, I paid too much or I took too little. Remember, if you go to trial and you knock it out of the park, I bet you it's going to be appealed, and it's going to be 2 more years before you even see 1 dime of this thing.
Yeah, I think that's a good point when everyone's a little bit like,
Yeah.
that's a sign of a very good settlement. So
No one believes me, but
great information.
It really is.
All right, so it's a lot of information. It can get convoluted, but the good thing is you can call Phil for a free consultation. He'll answer your questions for you. You can also go to our website, kwgn.com, click on Colorado's Best. You're going to see Phil's photo right there. You click on his photo, and then you can send him your questions directly. He'll answer them each personally and confidentially. And to reach Harding & Associates directly, here's his number, 303-762-9500. You can get a free consultation anytime. And you can find him online at hlaw.org. Well, still ahead on Colorado.